matter of Lauzikas and Secretary of State for the Home Department.
Yes, Mr. Trubinsky. Thank you for your timetable. We rather feel this is a day's case rather than a two-day case. And we would be more helped, if I may say so, if we could deal with the matter at the relevant stages, which are stage 1, stage 2, and stage 4. We would also be more helped, I think, by having submissions on the liability and quantum for each stage. And so what we propose, and tell me if you have fundamental objections, what we propose is that you should open your appeal by dealing with stage 1 and stage 4, and then Mr. Anderson can respond to that and open his appeal on stage 2.
My Lord, I must say we had rather thought that it would avoid duplication if we could deal with stages 1 and 2 together. I should say periods 1 and 2 because the judge referred to slightly different.
Well, that means that you respond to an appeal which has not yet happened.
That is indeed the difficulty, but our view, I think it's right to say it was a joint view, obviously subject to the court's agreement, is that this would avoid duplication, allow us to take events in the order that they happen chronologically, and of course deal with liability before quantum. But our primary concern, I think, is that there is such an overlap in the issues between our ground 1 and the defendant's ground 1 that there would be a great deal of repetition otherwise.
Well, I see that's what you want to do. We think it's inevitable. There's going to be an awful lot of overlap even on your approach.
My Lord, so be it, but of course in the court's hands, subject to anything that Mr. Anderson may wish to say.
I mean, my Lord, I can only echo Mr. Binsky. We thought that dealing with it chronologically, given that the issues and liability in terms of the legal principles are substantially overlapping, and there's just the question of how they're applied to those two different stages chronologically. And of course, if Mr. Binsky were to open in relation to that issue, she would have the reply to my appeal, and because the matters are relatively fully set out in the skeletons, we hope.
Yes, we appreciate, of course, that common issues arise in stage 1 and stage 2, but we think that you can deal with stage 1 and then move to stage 4. We would like you to try.
My Lord, certainly. And may I say, although perhaps introductions have been rather superseded, that I appear with Miss Pickup and Mr. Lauzikas.
Yes.
And of course Mr. Anderson appears for the Secretary of State.
Yes.
Although for simplicity I'll refer hereafter to the parties by their roles in the proceedings below. May I thank the court also for allowing us to move forward?
Of course, yes. Yes, thank you.
Just some housekeeping to start. You should have a core bundle, a supplementary bundle, 2 authorities bundles. And
yes.
there's also a loose leaf note that we sent in concerning Brexit and how that might affect any reference.
Yes. You can take it that we have, shall I call it a proper familiarity with the factual background. We understand what the stages are, and you no doubt may want to make specific points on the facts from time to time, but we think you can go to stage 1 and make your submissions as to why, contrary to the judge's view, that detention for 1 day was unlawful. Is Mr. Lauzikas in court?
He is not, he's in Lithuania.
He's in Australia?
Lithuania.
Sorry?
Rather close in Lithuania.
Oh.
Lithuania.
Right.
May I first of all hand up, we have sought to condense for the court's ease, and Mr. Anderson already has a copy, the issues that we say arise in the case. We've also produced a speaking note, although I must confess it adheres to the order that we had anticipated rather than the order that we're now following, but I still hope it may present a helpful roadmap to our submissions.
Can't help observing that's what skeleton argument is supposed to do.
Absolutely, but sometimes where there are so many issues, and there have of course been...
Well, only 3 issues.
We say there are 4, as you will see from our list of issues.
Well, 3 stages, yes, right.
3 stages, 4 issues, yes, my Lord. What I
wants to read this document?
Yes, well, certainly the issues, if I may ask you to do that. And what I propose to do, given the court's guidance, is first address you on the EU law relevant to liability, then turn to a summary of the facts. Now, what I had intended to do was actually deal with the facts all in one go. If the court prefer, I will only deal with period 1, and then make submissions on period 1, at which point I shall hand over to Mr. Anderson for period 2.
Well, we want you to do it at stage 4, of course, before you do that.
Yes, I beg your pardon, of course. If you could turn, please, to our speaking note and page 3 of that, top of page 3. Our overarching submission concerning EU law and liability in this case, applicable to both periods 1 and 2, is that the claimant during his detention benefited from a triple protection in EU law. First, protection of his liberty under the Charter of Fundamental Rights. The Court of Justice has emphasised the importance of the right to liberty, the gravity of the interference which detention represents, and the strict necessity test that consequently applies. Second, protection of his freedom of movement within the EU territories as a citizen of the Union, a freedom which he enjoys regardless of any economic activities, but rather as a result of what EU law considers a fundamental status of EU citizenship. And third, protection of his fundamental freedom under the treaties to work and take up offers of employment in the UK. So we say that the EU law protections in issue in this case, in particular those that apply to his freedom of movement and now codified in Article 27(2) of the Citizens' Directive, are sui generis. We say that the EU law challenges brought by both parties cannot, we respectfully emphasise, be viewed through the prism of domestic or convention principles applicable to deprivation of liberty, or through the familiar public law principles of reasonableness, as the defendant urges you to do. And still on our overarching submission, we say that the claimant's detention began here in an informational vacuum, which persisted barely ameliorated until the end of period 2. The only available explanation for the claimant's detention in both those periods, I'm anticipating period 2 here, is that it was based upon concerns that could only have arisen from the title of his offence, the length of the sentence imposed, and the fact that, but for any detention under the Immigration Act, he was due to be released from prison. So there was no assessment by the defendant of the claimant's past behaviour or of any likelihood that he might reoffend. There could not have been. And we say that both periods 1 and 2, in particular period 1, are marked by periods of inaction as to which the defendant has provided no explanation and elected to supply no witness evidence. And the defendant says that he can detain in these circumstances, and these are the words from the response skeleton of the defendant, for at least a short period pending a fuller inquiry. But of course, periods 1 and 2 lasted 29 days, a period in which the claimant was detained on the basis of minimal information. All of this we say was incompatible with applicable EU law protections for reasons that I shall now come to. So,
I'm sorry, just 2 points.
Certainly.
2 short points. First, he said there was no assessment of past behaviour or risk of offending. Do you also say that there was, and rely upon that there was no assessment of the risk of absconding?
I didn't say that actually, my lord, because there is at some point an assertion that, well, we're trying to deport him and therefore he might abscond. We would dispute the adequacy of that assessment, but what is entirely missing is any assessment of whether he is likely to reoffend.
Just on absconding, from my note, do do you accept that there was or may have been some assessment of absconder in this period, which is stage 1 and 2?
Not at period 1. So one of the points that defines period 1, of course, is that there's simply no reasoned decision at that stage at all.
Yeah.
Yes. So at period 2, there is some reference to absconding, but we say it's a circular reasoning and wholly inadequate. But period 1, not at all. There are simply no reasons offered.
Thank you. The second point is you referred to 29 days before there was at least an inverted commas a full inquiry. But you say that he couldn't be detained for any period.
My lord, that's right, and I shall come to the reasons why.
So it's not a reasonableness point.
No.
Your point is not a reasonableness point. It's as if it were an absolute point.
Well, my lord, as we shall see, I hope when we come to my submissions on period 1, we have both a maximalist submission, which my lord calls the absolute point, which is you simply can't detain on the basis of the fact and title of the previous conviction and the length of sentence, and certainly not on the basis of a presumption arising from those facts. That's the maximalist
Nor
submission.
for any period where it's necessary to get such information.
I'm sorry, my lord, I want to make sure that, so if...
I said nor, following your submission, he couldn't detain at stage 1, but you also say, as I understand as well, nor can he detain for such a sufficient, whatever period might be necessary to get the information.
Yes.
So in that sense, it is a bright line point.
Absolutely, my lord,
point,
yes. And
my
then
lord.
our fallback, our minimalist submission, is if that's not right, then in any event, the necessity standard dictates that if you are going to detain, in Mr. Anderson's words, for a short period pending a fuller inquiry, it has to be a short period and it has to be strictly necessary, which we say were not standards met in this case at period 2.
Yes, you support the judge's concept of imperative urgency.
My lord, we actually say that the judge there is not setting any threshold test. So we would
He said
say,
imperative urgency.
my lord, I'm anticipating now our submissions on period 2 rather, but we say there is no threshold test intended there. He is simply making the point that if one is in on our minimalist submission, sort of graduated scheme of necessity and proportionality, then the longer the detention endures, the more information you need. And what he is essentially saying is, I can accept that if it's necessary and urgent, you can have a short period, but it can't endure beyond that. And we would add that must be, because otherwise the prohibition in Article 27.2 upon reliance on previous criminal convictions taken alone or with a length of sentence would be rendered nugatory. If the Secretary of State could just say, well, for the time it takes, I'm going to rely on the criminal conviction and the length of sentence, and I will take my time, and when I get there, I get there. That can't be right. That simply renders the protection nugatory.
So is the submission really that if a period of time is allowable, and if that period of time is called a reasonable period of time, it must inevitably be short, and that's all the judge meant?
And it must be strictly necessary. Yes, yes, yes.
But
Which
it
is,
must be short, that's what the
Yes.
judge's point was.
yes.
You say.
And that the circumstances must be urgent. And of course, the
I don't understand why you're not accepting the judge's imperative urgency. It seems to me the concept of imperative urgency is rather more imperative than the time must be short.
My lord, we don't need to go so far. Even if he was simply saying you've got to have a short period, it needs to be necessary, it needs to be urgent. There's nothing exceptional in...
So you don't
in
like
that.
the concept of imperative urgency any more than Mr. Anderson does.
We don't accept that there is anything wrong with saying that if you are going to detain on the basis of minimal information, that needs to be something that comes to a close very quickly, and it needs to be something that happens because there is a situation of imperative urgency, not because the Secretary of State has sat on his hands for too long. What we do take objection to is the notion that the deputy judge was setting some kind of a threshold test. So the law is, of course, very familiar with the notion that one can have terms which set no threshold test, but which give guidance to a decision maker nonetheless. And one can think in the Article 8 jurisprudence about exceptional circumstances, for example, which have been said to set an expectation about the circumstances in which something will be permissible and proportionate, but nonetheless do not set a bright line threshold test. That's our point. But I'm getting ahead of myself rather, because I'm answering, as my Lord Justice Longmore said I should not, a submission that I have not yet heard.
But while you're doing that, and as the train of thought is still there, is the position this, that having taken someone into immigration detention with very limited information indeed, and there's no issue about the information, there is then an imperative, let's leave urgency out of it, there is an imperative to obtain all relevant information within as short a time as possible.
Yes,
that's it, is it?
Yes, yes, absolutely. And that it must be necessary to have that time. It can't be that the period of detention has essentially arisen for reasons of a casual approach to time, and it cannot be that one detains for that period and then doesn't actually do anything with that time. Yes. So if I may turn now to the EU legal context, you'll see at the front of the speaking note that we've handed up 6 premises of law on which the claimant's case is based. Now, most of these 6 legal premises are not controversial, and can I point out that, as your lordships and your ladyship will have noticed, the Secretary of State has now, unlike in the proceedings below, rightly accepted that each detention of an EU national worker for deportation is a restriction upon free movement, which must of itself satisfy the safeguards in Article 27.2 Citizens Directive. So the decision to detain, not just the decision to deport, must satisfy the Article 27.2 standards. And the reference for that very proper concession is Defendant's Appeal Skeleton, paragraph 57 at page 96 of the core bundle. I don't ask you to turn it up. And it's also reiterated in the Defendant's Supplementary Skeleton, paragraph 3 at core bundle, page 145. So in terms of where the dispute among these 6 premises arises, we understand it to be as to the scope of a necessity test, in particular what is a necessity test under Article 6 of the Charter of Fundamental Rights, and then premise 6 concerning presumption. Well, I'm sure that Mr. Anderson will soon, when it comes to period 2, tell me if I have overstated the extent of common ground. So, and we have also set out 4 legal errors that we say underpin the defendant's argument. But if I could ask you to keep that speaking note open, but turn up the first bundle of authorities. I'm now at premise 1. This is the uncontroversial premise about the Treaty on the Functioning of the European Union. And the extracts can be seen at tab 2. And I draw your attention to Article 21.1, that citizens of the EU member states have a right to move and reside freely within the territory of the EU, subject to the limitations and conditions laid down in the treaties and by the measures adopted to give them effect. That's Article 21.1 of TFEU at Authorities tab 2.
I mean, none of this is controversial,
No,
is it?
no.
So why are we going through it all?
Well, my Lord, because we say it's fundamental to understanding why there is such a problem with the siren invitation, if I can put it that way, from the defendant to apply purely domestic law principles to this case. And so this is the essential...
The judge didn't do that.
No, he didn't, but what
Why don't you spend your time attacking the judgment?
I take the point absolutely, my Lord. I shall then, in that case, I shall go straight to the Charter of Fundamental Rights, which is in dispute.
Right.
and which does go straight to period 1. Perhaps though, before I leave the TFEU, may I just highlight the other provision, which is 45.3, the right to move in order to work and take up offers of employment,
Yes.
subject to limitations justified on grounds of public policy, public security, or public health. Turning now to our premise 2, could you turn first to tab 1 of our authorities bundle? And this is Article 6.1 of the Charter of Fundamental Rights. I beg your pardon, Article 6.1 of the Treaty on European Union, I beg your pardon. So the Charter of Fundamental Rights shall have the same legal value as the treaties. And if you then turn, please, to tab 3, this is the Charter of Fundamental Rights. And I highlight very quickly, and then hopefully sideline, Article 6, the right to liberty and security. Article 15, which reflects the freedom of movement to work. And Article 45, freedom of movement and residence for citizens.
So this applies to the European Union.
Well, coming now to the field of application, that's dealt with at Article 51. So it applies to the member states when they are implementing union law. And we haven't included this in the authorities bundle because we don't understand it to be in any dispute, but the test that was set out in the seminal case of Flager is that the fundamental rights guaranteed in the legal order of the European Union are applicable in all situations governed by EU law. So where a member state restricts one of the fundamental freedoms, such as the freedom of movement, in reliance upon a derogation from the treaties or here in a directive, it is implementing EU law. So clearly we are in a case where that falls within the scope of the Charter. If you could turn now, please, to Article 52, which is of particular importance for our purposes. Article 52.1, any limitation on the exercise of the rights and freedoms recognised by the Charter must respect the essence of those rights and freedoms. Limitations may be made only if they are necessary. And then 52.3, we also highlight, insofar as this Charter contains rights which correspond to the rights guaranteed by the Convention, the meaning and scope shall be the same as those laid down by the said Convention. But then this very important proviso, which we shall see is important also in the jurisprudence, this provision shall not prevent union law providing more extensive protection. And I shall take you now, please, to 2 cases of the Court of Justice concerning the scope of the protection afforded by Article 6 to the right of liberty. Now, both of those cases concerned third country nationals who were not exercising free movement rights, but rather were seeking asylum. The first case is Al Chodor, which is at tab 15. And this case concerned the Dublin III regulation and the compatibility of Czech legislation and Czech practice towards third country national asylum seekers with the Dublin III regulation. And if you look at paragraph 37, there is a reiteration of the principle that any limitation on the rights recognised by the Charter are subject to the principle of personality, the principle of proportionality. and that insofar as the Charter contains rights which correspond to those recognised by the Convention, the meaning and scope of those rights must be the same as those laid down by the Convention, while specifying that EU law may provide more extensive protection. For the purpose of interpreting Article 6 of the Charter, account must therefore be taken of Article 5 as the minimum threshold for protection. So,
Yes, but again, is any of this controversial?
my Lord, I believe it is actually. This particular point about...
The judge accepted all this, didn't he?
The judge did, but
Yes,
this,
so please will you concentrate on attacking the judge?
my Lord, I think I do need to take you to the essential jurisprudence that underpins what we're going to say about period 1. So the judge certainly recognised that Article 6 applied,
Yes.
and he accepted the ultra law principle that Article 5 sets a minimum threshold only for Article 6. But we do say that this is a fundamental context for understanding why, as I shall show you in a moment, a strict necessity test applied, which could not have been satisfied in the circumstances of period 1. So if I may ask the court to bear with me and allow me to go through a little more on Article 6 of the Charter, I hope it will become clear why I'm going through this in this way. If you could turn to tab 17, this is the case of K.
Which tab?
17.
17.
And this case was
Is
about...
this mentioned in your speaking note?
It is, and we are now at premise 2, and it's simply referred to as K on the strict necessity test. So I'm coming on to why there is a strict necessity test in the Charter.
You say premise 2. Which page are we on?
I beg your pardon. So this is the opening page of the speaking note. So if you look at...
I thought we got to page 2.
No, my lord. I'm on 6 EU law premises, and I've gone very briefly through premise 1, and I'm now in the middle of premise 2, which is the Charter of Fundamental Rights. And I'm...
You don't refer to Chodor in paragraph 1. Whereas you do, I thought we had got to the second flaw on page 2, where you do refer to Al Chodor.
My lord, I beg your pardon, but I have somewhat reordered matters in light of the fact that we obviously had thought we would be proceeding one way and now are proceeding slightly differently. So may I show you K and why we say that it makes out the strict necessity test?
Yes, right.
And then I will be relying on that. So on K, please, this is a question concerning whether Article 8.3a of the Recast Reception Directive was compatible with Article 6 of the Charter. And if you look, please, at paragraph 69 of the Advocate General's opinion.
69.
69. So in the report, it's page 1422. It's at the top of page 1422. So it says, in view of the importance of the right to liberty enshrined in Article 6 of the Charter and the gravity of the interference with that right which detention represents, limitations on the exercise of the right must apply only insofar as strictly necessary, for which he is citing the case of N. And then if you look at 51 of the Advocate, if you turn back please to 51 of the Advocate General's opinion, you'll see that the question he is asking himself is whether the provisions of a directive are compatible with the right to liberty in Article 6. His answer at 52 of his opinion is yes, and the reason at 53, if you look under where he says thirdly, is that detention is only permissible when it proves necessary on the basis of an individual assessment of the case concerned, and if other less coercive alternative measures cannot be applied effectively. Turning now to a judgment of the court, if you could...
Sorry, Mr. Davinsky. Could you just pause a moment so that I understand what your underlying submission is? You're focusing on strictly necessary, I understand that.
Yes.
And this is necessary really in Article 52.1.
Yes, but it's
possibly other places too, but you've taken this to 52.1, but it's the same normative principle.
It is Article 52.1. What is important here, though, is that it applies with particular strictness to a deprivation of liberty.
No,
so
we'll come on to that. But necessary is a relative concept in this sense. Something has to be necessary for something.
Yes.
With some aim in mind. And in 52, it's necessary, for example, to protect the rights and freedoms of others. That's one reason why it might be necessary.
Yes.
Or it might be necessary because of general public interest. It might be.
Precisely, my lord. Although, yes.
I don't. I want to hear your submissions on this. Now, the assessment of public interest is essentially a matter for the state, the member state, the executive, essentially.
Yes, subject to the safeguards applied where one is not only depriving a person of liberty but restricting their freedom of movement, the safeguards applied by 27.2. So I shall come on to that in a moment, that our case is a fortiori al chodor, it's a fortiori K, because as I submitted at the start, we have a triple protection. We are deprivation of liberty plus freedom of movement. And so we have this strict necessity test, and then I shall show you that there are a series of specific safeguards which, in our maximalist submission, are not relative. They limit member states' discretion. So I think it's probably better if I deal with that when I come on to Article 27.2, but we say this is the underpinning for one of the protections that applied to the claimant, but by far not exhaustive of the protections that applied to him, because Article 27.2 then sets out specific safeguards, including, for example, a prohibition on reliance on justifications isolated from the particulars of the case, prohibition on reliance on previous criminal convictions, and so on. So those are in addition to the Article 6 protections.
But my, I hope, fairly simple point was that anything must be necessary for some purpose. But the assessment of that purpose, the assessment, for example, of the public interest or the protection of the rights and interests of others, that requires an assessment. Before you come to the assessment as to whether something is necessary to protect it.
Absolutely.
So the public interest requires some form of assessment.
Absolutely. And in Article 27.2, that I shall come on to shortly, Article 27 of the Citizens Directive is actually a division. So you have Article 27.1 that sets out the permissible grounds for derogation: public policy, public security, public health. And member states have latitude in how they define those concepts.
Correct, yes.
And I think that's what my lord is referring me to.
That's exactly the same.
But then the latitude specifically in cases based on the grounds of public policy and public security, that latitude is then, we say, stringently limited by the Article 27.2 safeguards. So the latitude as to is how do you say what public policy requires, but the latitude isn't, well, can I rely on previous criminal convictions alone? Can I rely upon justifications isolated from a particular case?
Thank you.
So turning back to K, if I can take you now to paragraph 37 of the judgment, and this is 1434. Of the report. So the Court of Justice explains that the principle of proportionality requires that measures do not exceed the limits of what is appropriate and necessary. And I think...
Where are you reading?
I beg your pardon. Paragraph 37, as regards to proportionality of the interference. And I think appropriateness goes to the point that my Lord Justice Hickinbottom was making. It's appropriate to what? There must be a legitimate aim, it's the public policy. And then it must be necessary in the same that less onerous measures could not have been as effective. And if you turn now to paragraph 40, there's then an explanation again of the point that I made earlier, that this applies with particular stringency in the context of liberty. And this is before one even starts to think about freedom of movement. So, in view of the importance of the right and the gravity of the interference, limitations on the exercise of the right to liberty must apply only insofar as strictly necessary. And at paragraph 48, so that the court finds that the directive that was in issue does satisfy that test, but then explains why. So while the proper functioning of the common European asylum system requires in practice that national authorities have at their disposal reliable information, those general requirements do not vitiate the need for an individualised necessity assessment. So the court says, Article 8.3 of a directive cannot justify detention being decided without the authorities having previously determined on a case-by-case basis whether detention measures are proportionate. And in particular, detention used only as a last resort must be ensured that detention does not exceed in any case as short a period as possible. And that completes what I have to say about the Charter. And if I can turn now to Article 27 of the Citizens' Directive, may I start by taking you to a few cases that we say explain the function of the Article 27.2 safeguard. So these are cases that precede the codification in Article 27.2 of the Citizens' Directive, but we think shed light upon it. And if you could start please at tab 8, this is the case of Rutili. And suffice to say in terms of the facts that this was a case about an Italian national worker and trade union activist who had been born in France and always resided there. And he'd been involved in the May 1968 protests. He was initially the subject of a deportation order that was revoked, and then he was a subject of an order which limited his ability to reside in certain départements of France. So he challenged that limitation on his right to move or reside freely within France. And at 27 to 28 of the judgment, this is, I think, going again to the I'm sorry, actually before, I beg your pardon, could I, before going to, could I step back for a moment to paragraph 21? So one of the questions that was asked to the court in Rutili was whether the protections in Article 48 of the EC Treaty, which was the precursor to Article 45 of the Treaty on the Functioning of the European Union, so it's the provision concerning freedom of movement for workers, and it's asked whether those limitations apply only to national legislation or also to individual decisions, and the answer is the latter. And if you turn please to 26 and 27, and this is, I hope, an answer to the question posed by my Lord Justice Hickinbottom. So member states are in principle free to determine the requirements of public policy in light of their national needs. Nevertheless, the concept of public policy must, and where in particular its use as a justification for derogating from the fundamental principles of equality of treatment and freedom of movement, be interpreted strictly so that its scope cannot be unilaterally determined by each member state. And then at 28, it said, accordingly, restrictions cannot be imposed on the right of a national any member state to move within it unless his presence or conduct constitutes a genuine and sufficiently serious threat to public policy. The court will see actually that is then reinforced in Article 27.2 by the insertion of the requirement that the threat be present, but I shall come to that shortly. And then CALFA is at tab 10. And on the factual context here, suffice to say that Ms. Calfa was an Italian tourist who went to Greece and used drugs there, and she was convicted of a drugs possession offence. And Greek law at the time provided that a foreign national convicted of a drugs possession offence must be expelled for life absent compelling reasons. I'll just give you the reference for that. It's paragraphs 5 and 9 of the judgment. So there was effectively a presumption of a ban on re-entry for people convicted of a particular class of offence. And then paragraph 23 of the judgment, we have a reiteration of the principle already seen in Rutilli. Public policy exception, like all derogations from a fundamental principle of the treaty, must be interpreted strictly. And then we see that limits that were set down in the predecessor directive, so before Article 27.2 Citizens Directive, imposed safeguards upon the circumstances in which member states could restrict freedom of movement. The safeguards, which at that point were less strong, were contained in Directive 64221, which is being referred to there. And it said Directive 64221 sets certain limits on the right of member states to expel foreign nationals on the grounds of public policy. So there is a discretion which is then limited by those specific safeguards. And then paragraph 24, we see also that such restrictions must be based exclusively on the personal conduct of the person concerned. Previous convictions cannot in themselves constitute grounds for taking such measures. Follows that the existence of a previous criminal conviction can therefore only be taken into account insofar as the circumstances which gave rise to that conviction, I emphasise that phrase, are evidence of personal conduct constituting a present threat to the requirements of public policy. You can't look at the fact that the person's been convicted of a certain class of offence, like Mrs. Calfa's drugs possession offence. You have to look at the circumstances which gave rise to that conviction. And at paragraph 27, it said that this is an impermissible automaticity of the national legislation. We might in fact quibble that because the Greek legislation actually said you'll be banned for life absent compelling reasons. It's in fact a presumption, it's a rebuttable presumption, but the court is saying, it's calling it impermissible automaticity and saying that the Greek legislation fell foul of that safeguard. And then paragraph 29, we see a reiteration that such legislation is inconsistent with EU law. And similar legislation is then considered in Orphanopolis, which is the next authority, and this is quite central for our case. And this is about two migrant workers from Greece and Italy who lived in Germany. And they had both been convicted of drugs offences. Mr. Orphanopolis also was convicted of crimes of violence. And if you look, please, at paragraph 50 of the Advocate General's opinion. I'm sorry, actually, before I go to that, can I ask you to stop at Advocate General's opinion 46? Five lines up from that, from the bottom, a present and specific threat, that is to say, the existence of a particular risk is required. Therefore, it may be inferred from the court's case law that assessments may not be made on the basis of general consideration. And then at paragraph 50 of the Advocate General's opinion, it may be deduced from the case law that the competent authorities of the member state must base their decision on an assessment of the future conduct of the individual concerned.
That's paragraph.
I'm sorry, 50 of the Advocate General.
Thank you.
And he's, of course, construing there the prohibition on treating previous criminal convictions as constituting grounds for the taking of restrictive measures. And if you go on to 111 of the Advocate General's opinion, so according to the court's case law, when the future conduct of the individual concerned is assessed for the purposes of a law relating to aliens, there's a duty to consider whether there's a genuine and sufficiently serious threat to one of the fundamental interests of society. General considerations are prohibited. Such general considerations exist where national law makes expulsions mandatory in general and abstract terms. Such legal constructions prevent a substantive examination of a specific case. In any event, the application of a general and abstract provision to a specific case is not consistent with the prohibition on general considerations. So this is evident precisely in legislation such as that in the main proceedings, which lays down standardised criteria on the basis of which a particular threat is inferred. And I shall show you the German legislation in a moment. It's very convoluted, but the essential point is it imposed a rebuttable presumption that individuals convicted of drugs offences and sentenced to a certain period of imprisonment would be expelled. And there was also what seems to have been a rebuttable presumption that in such cases there would be serious grounds on which to carry out the expulsion. And if you look now to the judgment, please. If you turn, please, to sorry, I'm trying to find the best explanation of the legislation. If you look at paragraph 27, so in certain circumstances which apply to Mr. Orphanopoulos' case, the expulsion order was not mandatory but was a general rule, i.e. it was presumptive. And if you turn, please, now to 64, this is the court's analysis. So there's an emphasis on the familiar principle that freedom of movement for workers must be given a broad interpretations, whereas derogations from the principle must be interpreted strictly. And then a particularly restrictive interpretation of a derogation from that freedom is required by virtue of a person's status as a citizen of the Union. So this is coming back to my point about triple protection. You have deprivation of liberty, freedom of movement as a worker, and then a particularly restrictive interpretation where you moreover have an EU citizen whose freedom of movement is being restricted. And Then 66, interpreting Article 3 of Directive 64221, measures to be justified must be based exclusively on the personal conduct. And the concept of public policy presupposes the existence, in addition to the perturbation of a social order which any infringement of a law involves, of a genuine, sufficiently serious threat to the requirements of public policy. So it's not enough to say, well, it's in the interest of public policy to remove people who have been convicted of your particular class of offence. You've also got to show that this particular person poses a future risk over and above that, the public interest in removing convicted offenders.
You have to look beyond the public interest of removing offenders, don't you?
Yes.
You look at why that is in the public interest. Maybe in the public interest because they might do all sorts of things. They might commit further offences.
Precisely. But my point is, you can't simply infer the public interest in removal from the fact that a person has been convicted of a particular class of offence. You need to look at whether this individual will, in future, pose a threat to one of the fundamental interests of affecting society, which ordinarily means reoffending. So I say ordinarily because in particularly heinous cases there is an exception, it doesn't apply here. Yeah. But the ordinary position where you have an offender that's being, where a restrictive measure is being considered, is that you are looking at the risk of reoffending. Yes.
Just give me a moment. So generally speaking, the public policy that we're really focusing upon is the public policy of individuals not reoffending.
Yes.
And that public policy, as I understand it, is set by the member state, where it may be obvious. Where the restrictions come in is that the threat to that public policy must be sufficiently serious.
And subject to a host of other safeguards.
Yes.
So for example, in our domestic jurisprudence concerning Article 8, it's sometimes been said, for example, that one might look at deterrent consequences of deportation. And certainly not making any submissions on whether that falls within Article 8, but if it did, it's certainly not permissible in EU law. So you can't say, well, I'm going to protect the public by sending a very strong message that we are going to deport drugs offenders, because that would be a consideration isolated from the justifications of the case. You can't, the EU law is absolutely categoric, you cannot rely on deterrent considerations. So,
I thought this was all codified in the Citizens Directive.
It is, but what we're trying to show is the structure, which we say has not been understood by Mr. Anderson. I'm sorry, I know that your point is, I quite take it, my lord, that we should be attacking the deputy judge and not the Secretary of State. But if I could put it this way, Mr. Anderson did persuade the deputy judge that there was some possibility of a de minimis period where you could effectively depart from or dilute the Article 27(2) protections.
I'm not sure about that.
Well, we're saying that
what the deputy judge said was that there was sufficient individualised personal information available on the day, stage 1, to justify detention for the purpose of getting the further information with imperative urgency to see whether deportation was going to occur.
My lord, quite so, but we say in circumstances where all that's known, other than the identifying details, the fact that it's first conviction and the fact that the person may eminently be released, but all that's known is the title of the offence and the length of sentence. We're squarely within the orphanopolis prohibition, which is you can't presume...
Well, you're squarely within Article 27 of the Citizens Directive, you would say.
We're squarely within the particular prohibition of Article 27(2),
Yeah.
which Orphanopolis, the reason I'm taking you through this before I go to 27.2, is that Orphanopolis sheds light on what that safeguard means. So the safeguard that says you can't rely on previous criminal convictions alone actually extends also to relying upon the class of conviction and the length of sentence. So Orphanopolis shows us that. And Orphanopolis also shows us that you can't even presume in favour of expulsion or another restrictive measure on the basis of the class of conviction and the length of sentence. So we say the only way in which what happened in the claimant's case in period 1, where he is detained in an informational vacuum, no reasons, no information really other than the class of sentence and the period of imprisonment, the only way in which that works is if the deputy judge has effectively accepted what Mr. Anderson says, which is when it's very urgent, when it's for a short period, when it's really necessary, we have a discretion under Article 27.2. That's Mr. Anderson's submission. And
A discretion to ignore the 27 principles, you say.
yes, ignore or at best dilute.
Yeah,
And our point is, firstly, of course, no authority of EU law says that. It's striking me, a venerable line of jurisprudence here going back some 45 years, going back to Van Duyn, which I shall show you to later. No authority has ever said that there is some discretion as to the safeguards. But also we say it's wrong in principle, because what these safeguards do is not confer a discretion on member states, but limit the discretion of member states to derogate from the fundamental freedoms. So Orphanopolis goes to our maximalist submission, which is that you simply cannot, and I shall show you shortly the terms of Article 27.2 of the Citizens Directive, which are unequivocal and mandatory. You cannot depart from or dilute these safeguards.
But there's another way of looking at this, isn't it? What the cases say, and I know they say sometimes because of the facts of the individual cases that you can't rely upon the fact of conviction of a particular offence generically. But I mean, doesn't that depend on what the offence is? The mischief that these authorities are aimed at is assessing the risk posed by an individual by some generic criteria. That's the mischief that these cases are aimed at. But the nature of the offence might be specific. For example, the offence might have a specific intention. And so that is some information about the offence. What's wrong with looking at that?
Well, we do say, and I shall take you to the authorities that show you this, one has to look at the behaviour ordinarily that underpins the offence. I think we can see two exceptions to that. One is you might have a category of offences where there is some evidence to which the Secretary of State can point that a person who has been convicted of this offence is very likely to reoffend. So there might be particularly compulsive offences, for example, sexual offences. One might have some evidence that one could say, well, if you have committed this, that's indicative of a propensity to reoffend. If the Secretary of State could point to cogent evidence, we can see that that may well meet the Article 27.2 concern. The other situation you might have is where you have someone with a list of previous convictions, the length of one's arm, where every time this person has been released, they've been redetained. And so you can see from the pattern of conviction a propensity to reoffend, absent some information that the person has reformed. But those are not the circumstances here. The Secretary of State has never said that they are. So what the Secretary of State's case is really about the claimant's offending is, well, we knew it was serious because we knew the title of the offence.
With a specific intention.
My Lord, and so we say that doesn't give an indication of whether it is likely to reoccur. All that is doing is saying, if it recurs, it's serious. But that's not enough. One actually has to have some evidentially based assessment of whether this person has a propensity to reoffend or say in some other sufficiently serious way affect the fundamental interests of society in future. So
Propensity will be demonstrated by previous convictions.
well, it can't be, my lord, otherwise that
So
can't...
why are you accepting that propensity is something which the Secretary of State can take into account?
Propensity, we say, is vital. It's not that they can take it into account, they must take it into account, my lord. So we say it could be that you have a pattern, a long pattern of recidivist offending that indicates propensity to reoffend.
Then it'd be all right to be aware of previous convictions and proceed
Yes.
accordingly.
We're not saying you ignore previous conviction, but we're saying you must have some evidentially based assessment that this person is likely to reoffend.
But
And-
if he had a specific intention as part of the offence, isn't that going to make that more likely?
My lord, not necessarily. We can't see why. It could be one may have an entirely one-off incident. My lord, we do say, first of all, it has to be some justification what the Secretary of State actually pointed to. So we are, as it were, also an informational vacuum here because the Secretary of State has elected not to adduce witness evidence. But there needs to be some reason from the Secretary of State that is what they're doing. But also, my lord, there's great respect that there's no reason why that should be so. A person may have in a particular set of circumstances an intent to cause fear and alarm, for example, but that does not indicate that they're going to do it again. There has to be some understanding of the behaviour, the facts that underpinned the offence. Otherwise, one is back in the territory of the Article 27.2 prohibition. So we do say it can't be that you can, in answer to the question posed by my Lord Justice Longmore, it can't be that you can infer future risk simply from the title of the conviction. Otherwise, the whole prohibition upon reliance on previous criminal conviction is rendered nugatory.
So in terms of the risk of reoffending, there really would be three sources of information. One, the facts of the particular conviction. Two, any previous and relevant convictions. And three, any assessment of the likelihood of reoffending in the pre-sentence report. Those really are the three factors, aren't they?
Absolutely, my lord.
In making this assessment, because we all know that in assessing risk there are two elements. One is chance, which we've been discussing, the probability, the mathematical probability of something happening. But the cases talk not actually about risk. The European cases talk about threat to the public policy. Can the member state take into account not simply the probability but also the consequences in assessing threat to the public policy of reoffending?
It must take both into account, but not only one. And only one was taken into account here.
Yeah. So, for example, if somebody had murdered somebody,
Yes.
the member state would take into account the not just the probability of something happening again, him reoffending, but the consequences of him reoffending possibly in this way. But you say that if there's no assessment of the chance, of the probability, then that's really the end of it.
Yes.
Because you've got to take that into account, or whatever the potential consequences.
Yes,
the logic question.
And, my lord, may I, on that point, actually take you to a case that says just that? May I ask you just keep volume 1 in Orphanopolis open, because I'm not quite finished with it, but just in answer to that question concerning the two limbs of threat. If you could turn to volume 2, paragraph 32, tab 38. And this was very appositely given the question that was just put to me about a murderer, a convicted murderer, who was exercising free movement rights. And could I just take you to page 51 of the judgment of Mr. Justice Walker. Page 51, subparagraph 3 of the conclusions. I recognise that X's conviction was for an offence of murder. the seriousness of that offence might be such that even a low risk of reoffending could justify a decision to detain, but it's elementary that a conclusion to that effect cannot be reached merely from the fact of the past conviction. It's necessary to have regard to the period as past that the offence was committed, to the conduct of X during that period, and to factors which tend to reduce the risk of reoffending. And we would add, look to the circumstance of the offence, look to assessments that have been carried out, as my lady pointed out. So it is necessary to look to all.
Slightly odd statement, because having regard to the various past since the offence was committed, if it's a murder case, he's going to be in prison, isn't he?
My lord, yes. My lord, yes. I
don't follow the logic of that really at all.
Well, it might be that somebody had reformed in prison and that there was evidence, evolution, rehabilitation in prison and evidence of it.
It
So,
would probably go to the minimum term.
yes. Thank you. Yes.
Well, obviously, if there's been a minimum term and he's now out, a lot of information will be available about it on any view, won't it?
And my learned junior's pickup helpfully points me to paragraph 1, but actually explains that Mr. Justice Walker's conclusions were not mystifying, because actually his offence had been committed in Romania. So it was a long ago offence. So it's not a situation where someone reaches, has committed the offence here and completed their custodial term here. Yes. So turning back to, without digression, to Orphanopoulos, we were at paragraph 65. This is directly on the point that I had just been asked. I'm sorry. I'm sorry, 67. I beg your pardon, 67. The public policy exception must, however, be interpreted restrictively, because it's halfway through 67, with the result that the existence of a previous criminal conviction can justify an expulsion only insofar as the circumstances which gave rise to that conviction are evidence of personal conduct constituting a present threat to the requirements of public policy. And then paragraph 68 says the point that I made earlier about the prohibition upon deterrent considerations. And then if you look, could I ask you to read paragraph 69 to 71. That's the conclusions concerning the German legislation, although we will see more about it in a moment.
Yes, so in this country we do have provisions applying to non-EEA persons, do we not, that there is a presumption in foreign convicted offenders that if it's more than so many years, they must go.
Precisely, and that's
But no one suggests that does apply to EEA members.
No, but we do, what we do say is that, in effect, what happened here was an impermissible presumption in favour of a restrictive measure. Could I take you to paragraphs 90 onwards now, the judgment deals specifically with the question of presumption? So, here the court is considering whether Directive 64221, the precursor to Article 27.2, precludes national legislation which provides for expulsion as a general rule, a rebuttable presumption, in respect of nationals of other member states who receive certain sentences for specific offences. And at paragraph 93, the court explains why such a presumption is objectionable. If it does indeed have such an effect, that means that the expulsion of a national of another member state who has received a particular sentence for specific offences is ordered despite family considerations being taken into account on the basis of a presumption that that national must be expelled without proper account being taken of his personal conduct or of the danger he represents for the requirements of public policy. So the premises that I showed you in the hand-up note, that was premise 6, which I've taken out of turn. So we say that Orphanopolis is, as is Calfa, authority for the proposition that you cannot have a rebuttable presumption even that persons convicted of a particular class of offence, sentenced to a particular length of imprisonment, will have...
As I understand, there's no part of Mr Anderson's argument that rebuttable presumption is okay.
Well, my lord, I'll take you to that, actually. Mr Anderson, actually, his argument seems to be you can't have it in legislation, but you may be able to have it in individual decision-making. I was going to take you now to a directive. I could take it on a detour to Mr Anderson's argument, but what Mr Anderson does is try to distinguish Orphanopolis on the basis it's about legislation, not about individual decision-making. And to that, our answer is, well, see what was said in Rutilli, for example, that these prohibitions are not limited to the national statutory regime. They're about safeguards that apply to individual decision-making. The other reason why this is so important in this case is that Mr Anderson submits, and that was not a submission accepted by the Deputy Judge, that the Secretary of State was able to conduct an adequate assessment of threat in this case because the Secretary of State operates a policy of treating certain offences as more serious and as usually justifying detention. I was intending to take you to that policy later. If it assists, I can take you to it straight away.
No, I don't think we need that.
But it's a central part of Mr Anderson's explanation for what happened, even though, of course, we have no witness evidence. We don't know quite whether this policy was applied to the claimant. But taking Mr Anderson's case at its highest, he's pointing to a policy that effectively presumes in favour of detention for certain offences without distinguishing between third country nationals and EEA nationals on that policy. And we say, well, if it's right that that was applied to the claimant, that makes Mr Anderson's position much worse, because that is an Orphanopolis type presumption. So could I take you now to the directive, which is at tab 4. And could I, in the recitals, page 78 of the report, highlight recital 3, union citizenship should be the fundamental status of nationals of the member states when they exercise their right of freedom of movement and residence. And then the last line, but the purpose of the Citizens Directive is to strengthen the right of free movement and residence of all union citizens. So we earlier looked at a line of jurisprudence that deals with Directive 64221. This intends to strengthen the position. And could you turn please to Article 27 now? So Article 27 is headed general principles. It's not specifically limited to expulsion. So it's general principles concerning, as we see above, restrictions on the right of entry and the right of residence on grounds of public policy, public security, public health. And this is the structure that I mentioned earlier, that Article 27.1 allows derogations on these specific grounds, public policy, public security, and public health. And then Article 27.2, where decisions are taken on grounds of public policy or public security specifically, sets out a set of discrete protections, each of which we say must be satisfied in full and in itself, as we saw in the jurisprudence. So, shall comply with the principle of proportionality, which, and I think this is not in dispute, the principle of proportionality in EU law, of course, always entails a necessity test. Shall be based exclusively on the personal conduct of the individual concerned. Justifications isolated from particulars of a case shall not be accepted. Previous criminal convictions shall not, in themselves, constitute grounds for taking such measures. And I emphasise, of course, the mandatory and unequivocal terms. And the personal conduct of the person concerned must represent a genuine, present, and sufficiently serious threat affecting one of the fundamental interests of society. And could I show you also Article 28? So that's a provision that specifically applies to expulsion, and it applies additional safeguards. And one point I would highlight, and it's a common ground between the parties, that of course this means that the factors that underpin the decision to detain may not be entirely the same as those that underpin the decision to deport, because there are complex questions that arise in an expulsion decision of a person exercising free movement rights concerning length of residence, continuity of residence, quality of residence. So depending on the type of residence that a person has accrued, they may enjoy enhanced protection. And I shall turn ahead now to what are premises 4 and 5 in the list of EU law premises. I shall first of all, and these concern the way in which the administrative detention of a person exercising free movement law fits within this scheme of protections of EU law. So, and I'll ask you to please turn to the case of Ulaine, which is at tab 12. And so Mr. Ulaine is a French national twice stopped by the Netherlands authorities on grounds of suspicion of illegal residence. And he, at paragraph 41, so it's asked whether his detention was permissible in EU law. And it said at paragraph 41, I beg your pardon, that a detention order can only be based upon an express derogating provision which allows member states to place restrictions on the right of residence of nationals of other member states insofar as such restrictions may be justified on grounds of public policy, public security, or public health. And then at 51, I'm sorry, 44. So this is impermissible if there is no threat to public policy. So Ulaine is authority for the propositions that a detention of a person who is exercising free movement rights is a restriction of freedom of movement and is permissible only if authorised by the express derogating by an express derogating provision. And at this point, I was going to take you to the domestic regulations and to the domestic statute. Given time, what I propose to do, unless it would specifically assist the court, is go on straight to the Noailles litigation on the assumption that the legislation is already familiar to the Noailles litigation. So the Noailles litigation is of some importance in this case. Right. If you turn, please, to case of Noailles, which is in Authorities 2 at tab 30. So, Mr. Noisley was actually a third country national, but by virtue of his marriage to an EU national, was exercising free movement right. And he was a prolific offender. He'd been convicted of 48 offences. And at first instance, Mr. Noisley had, and we can see this at paragraph 8 of the judgment, he had not challenged his detention on the basis that it was unjustified or unreasonable or disproportionate in his individual case. Rather, what he said is, there's no basis in EU law for my detention. That's, you can see paragraph 8. And in paragraph 9, we can see that at first instance, Mr. Justice Edis said, no, there is a basis in EU law for your detention. It's Article 27.1 of the Citizens' Directive. And he then says, but that's subject, of course, to the other requirements of that article. And Mr. Noisley appealed to the Court of Appeal on the basis that he argued that Article 27.1 of the Citizens' Directive could not authorise in any circumstances administrative detention pending deportation. And at paragraph 11, at F onwards, we see that Lord Justice Morbick, with whom the other members of the court agreed, said, no, that's not right. Detention is a restriction of free movement. And therefore, 27.1 could justify a temporary restriction on freedom of movement short of expulsion, but that was subject to the limited grounds upon which freedom of movement can be restricted and on the need for proportionality. And then at paragraph 16, Lord Justice Morbick is addressing a particular point that was raised from Mr. Noisley, that there were no express time limits in national legislation. And he said, well, that's met by the proportionality safeguard. And I should point you, in fairness, to a passage on which Mr. Anderson relies, where he says, well, this is at page 3321D, I think his understandable concerns about the failure of Article 27.1 to limit the permissible period of detention are met by the requirement of proportionality.
Where are we now?
I'm sorry, it's page 16.
Page 16.
I'm sorry, paragraph 16.
Yes.
3321D. So, Lord Justice Morbick is saying that Mr. Justice Eder's understandable concerns about the failure of Article 27 to limit the permissible period of detention are met by the requirement of proportionality, which provides a kind of protection similar to that in Hardiel Singh. So this is the higher point for Mr. Anderson.
Whose concerns are we talking about?
Mr. Justice Edis at first instance. So at first instance, the first instance judge had said, well, I do think that Article 27.1 can authorise detention.
Yeah.
But he said, I'm rather concerned by the lack in domestic legislation of a time limit.
Right.
And Lord Justice Morbick is saying, well,
Yeah.
proportionality, and he says, which provides a kind of protection similar to that in the Hardiel Singh principles, deals
Yes.
with the problem. But I will make 2 points about that. One is, of course, this is obiter dicta, because there was no permission for Mr. Noisley to argue that his detention was disproportionate or unreasonable. The other point that we make is that there is, of course, a fundamental distinction, I shall come on to that, which is that at least on the present interpretation of domestic law principles applicable to administrative detention, there is no strict necessity test in domestic law, but clearly there is in EU law. So one need look no further for that distinction than, for example, the Saudi jurisprudence. So it's been held by the House of Lords that domestic law can accommodate short-term detention for reasons of expediency, absent an individualised proportionality assessment and absent a need for each detention to be necessary on its own facts. but that could not be consistent with the strict necessity test in the law. And at paragraph 30, Lord Justice Morbick then analyses the previous criminal convictions safeguard. And I draw your attention in particular to the line below H, it is paragraph 30H. What matters for these purposes is the behaviour rather than the conviction.
Yes.
So, the Court of Appeal's judgment in Noasley, unless displaced by the Supreme Court's judgment, which it was not, as I shall show you, is binding authority for the propositions that the administered detention for the purpose of deportation of a person exercising free movement rights is a restriction within the terms of Article 27.1 of Citizens Directive, and that such administered detention must comply with the requirements of Article 27.2. And it's also persuasive authority. As I said earlier, there was no permission for Mr. Noasley to argue the reasonableness or proportionality point. It's also persuasive authority that what matters for these purposes is the behaviour, not the conviction. And I now turn to the Supreme Court's judgment, which is at tab 33. And Lord Clark gave a leading judgment with all the other, with which all the other members of the court agreed. And could I just show you that the issues in the appeal are summarised at paragraph 4. And could I highlight in particular issues 2, 3 and 6. So by the time he reached the Supreme Court, Mr. Noasley had different representation. And what he was arguing was, well, yes, Article 27.1 can in principle encompass the detention of a person exercising free movement rights, but he said the particular power under which he was detained it was not necessary to have such a power, and he also complained that the lack of time limits was incompatible with EU law. So he, again, did not and could not argue that his own detention was disproportionate or unreasonable. And at paragraph 75, we see I'm sorry, I should turn you back. I'm sorry, before turning ahead to 75, could you look at 62, please? Not in dispute that Regulation 24.1 must be applied proportionately. And then he said, well, I don't see then, if it's not in dispute that it was applied proportionately on Mr. Noasley's fact, how can the existence of the power be disproportionate? And he said, well, in that case, the only basis really on which a complaint can be made here is the lack of time limits, issue 3. And paragraph 63 onwards, Lord Clark turns to the question of whether the absence of a time limit renders the detention disproportionate, the detention power disproportionate and unlawful. And he then takes in a detailed assessment of the Strasbourg jurisprudence and the Hargill-Singh principles to see whether there is a requirement in the Strasbourg jurisprudence of time limits or in EU law, or whether the Hargill-Singh principles satisfy concerns about the lack of specific time limits. And if you look, please, at paragraph 70, you see the last line of 69 just above it. There's no suggestion in the Strasbourg judgment, and he's referring to SARDI, that a firm time limit is required. And he then says, nothing in the broad dicta in the Court of Justice cases referred to on behalf of the claimant demonstrates a narrow approach in EU law. So I take you to this because Mr. Anderson relies on these paragraphs as authority for the proposition that the Hargill-Singh principles are coextensive with the protections of EU law for the purposes of this case. But Noasley is not authority on any proper reading, we say, for that proposition, because what is being said here is EU law requires no more as concerns time limits than does Article 5.1f or than do the Hargill-Singh principles. So if you...
So what in your submission is missing from the Hargill-Singh principles?
A strict necessity test we would start with. So I just made the point that earlier that the House of Lords judgment in SARDI is, of course, finding authority for the proposition that in principle a short period of detention for reasons of expediency, not based on an individualised detention, an individualised proportionality assessment, is permissible in domestic law. So no strict necessity test, and we would also say, of course, the particular safeguards of Article 27.2. So in the SARDI litigation, it was permissible for the Secretary of State, for those purposes, to rely on general considerations isolated from the considerations of particular cases before him. So the Secretary of State could rely on considerations of expediency and cost. But that is precisely what Article 27.2 prohibits. So we say there is a gulf between, on the one hand, the EU law protections that apply here, and on the other, the Hargill-Singh principles and Article 5.1f. We don't bring a challenge in domestic law to period 1, so we don't need to make detailed submissions as to the scope of Hargill-Singh or Article 5.1f. What we can say, and we say it must be clear, is that those protections are not coextensive and cannot be coextensive. So I shall show you in a minute, for example, that it has been categorically said, and it's the current state of the law on Article 5.1f, that there is no necessity test in Article 5.1f. So one cannot conflate these distinct protections as the defendant seeks to do.
Wouldn't one expect your leader in that case to have taken that point if he was saying that the regulations are not conforming with Article 27?
My Lord is asking me about Noasley. So yes. Why didn't he take the position that EU law offered more? My Lord, I hesitate to give evidence. I think that was part of the submission, but what was also part of the submission was that Article 5.1f, there were a series of cases which indicated a growing recognition by the Strasbourg court that time limits, at least where there was no automatic judicial supervision of detention.
You were arguing in that case that the regulations were incompatible with Article 27.
Yes.
This now seems to be a point that your leader missed.
My Lord.
Your now point.
Well, my Lord, can I emphasise that what was being argued there was specifically in the context of time limits. So what was argued in that case was, look, there is a series of Article 5.1f cases that suggest you do need time limits, and of course EU law is a fortiori. It's not actually, there we were relying on Article 5.1f for supporting our point, and the Supreme Court comes back and says, actually, we don't think Article 5.1f does require a time limit, and we don't think EU law does either. And we say these paragraphs go no further than that, which is to say, for the purposes of time limits, EU law imposes no more stringent restriction, or no more stringent requirement than Article 5.1f or the Hargill-Singh principles.
They rejected your argument that the regulations did not comply with Article 27.
Yes.
Now, surely we're bound by that conclusion.
Yes, we don't dispute that. Yes, but nothing in the regulations says, as occurred in period 1, you can detain without a reasoned decision on the basis of information only about previous convictions and a length of sentence. That wasn't the issue in Wesley.
I see that for stage 1, yes.
Yes, and nor does anything in the regulations themselves deal with the question of duration. So, parenthetically, I will come on to the fact that, in fact, the defendant himself clearly does recognise that there's a distinction between the protections applicable to EU nationals and those applicable to those, and protections applicable to those who are not exercising EU law rights, because the Secretary of State has a distinct detention policy. Yes. So, interestingly, the Secretary of State actually does require absolute necessity and a 2-week time limit for detention before the making of a decision to deport. But I'll come back to that later if I may, but on these passages in Wesley, my point here is that these passages, which form, again, a very central part of the defendant's case, are not authority for the proposition that the Harjil-Singh principles are generally, coextensive with the protections of EU law. So, for example, 71D, none of the cases cited on behalf of the claimant in his case support the contention that mandatory time limits are a necessary component of the quality of law. They turn on very different facts, and then at the bottom of 71, there's nothing to suggest that time limits are a general requirement of Article 5.1f. And then at 76, the last sentence of 76 says, I would accept the submission made on behalf of the Secretary of State, but it gives no reason to suppose that EU law requires more in this particular context than the Convention of Protection of Human Rights and Fundamental Freedoms. So, if you then look at 78, all of this is being said in the context of rejecting the case for the claimant that EU law required time limits. And that is the particular context that's referred to at 76. Could I turn you now to the judgment for a moment and what the Deputy Judge had to say about these passages? So this is core bundle. And it's paragraph 29 of the judgment. Page 178 of the core bundle. And so it's 178 to 179. If I could show you in particular the last sentence of 29, those passages are discussing the duration of immigration detention, the suggested requirement of a statutory maximum time limit to meet proportionality and certainty standards. So, and we respectfully say that's precisely right, and that these are not authority for any broader proposition that EU law protections for liberty are somehow coextensive with the Harjil-Singh principles. If I could ask you to turn back, please, to our speaking note and to the flaws in the defendant's arguments, and I shall take these very briefly, mindful of the guidance to go quickly to the Deputy Judge. Firstly, the Secretary of State's argument is that he enjoys a margin of appreciation as to the Article 27(2) safeguards. We say that is manifestly wrong given the structure and function of Article 27(2), which is to limit the discretion of member states to derogate. There is also the point, and I was asked earlier, what does Mr. Anderson say about orphanopolis? The reference is supplementary skeleton Corp under 148, paragraph 12, where Mr. Anderson says, well, orphanopolis is about legislation, not about individual acts. And as I have already submitted, that's a distinction without a difference. The principal point for Mr. Anderson is his attempt to equiparate EU law protections applicable to the deprivation of the claimant's liberty with those that arose under Article 5(1)(f) and the Harjil Singh principles. And in addition to the cases that I've already shown you, we say that there are a number of reasons of principle why this cannot be right. Taking first Article 5(1)(f), we've seen from Al-Chodor that Article 5 sets a minimum threshold, not a ceiling, for the Charter of Fundamental Right protections. Next, Article 6 always imposes a necessity test. Sadi in the Grand Chamber is high authority that Article 5(1)(f) contains no such test. Could I ask you just to turn that up quickly? That is at Bundle 5, I beg your pardon, Authorities Bundle 1, tab 19. And could I ask you to go to 451 of the law report. This is paragraph 72 of Sadi. So there is a reference here to the Grand Chamber's judgment in Chahal, which is being followed here. No requirement that the detention be reasonably considered necessary, for example, to prevent the person concerned from committing an offence or fleeing.
I think the next sentence is relevant too, isn't it?
Absolutely, but that is the, in a sense, that is the baseline of the Article 5(1)(f) protection, which is you must have deportation proceedings in progress, and provided that they are pursued with reasonable diligence and expedition, which is essentially the standard that Mr. Anderson urges upon you, that suffices. But that is not the standard in this case, because we have a strict necessity test, and the Grand Chamber in Sadi specifically says no necessity test applicable. And of course, the point I made earlier, Article 27(2) applies a series of discrete protections that have no analogue in Article 5(1)(f). So if we look at paragraph 80, and this is also applicable to what the House of Lords said in Sadi about domestic law, the bases on which fast-track detention was found to be potentially compliant for a short period with Article 5(1)(f), well, it's inconceivable that those could be consistent with the Article 27(2) safeguards.
Yes, well, these are all arguments to meet the Secretary of State's arguments.
Yes.
We'd better hear his arguments first before we go to the detail of that.
Quite. May I show you the serious offences policy, however, while we are, before leaving the Secretary of State's arguments altogether?
Yes.
If I may ask just for your indulgence for that last point. So, I won't ask you to turn it up, but in paragraph 62 of his appeals letter, the defendant says the requisite harm assessment was in fact carried out because there was a policy that defined certain offences as serious. So, to the extent that we have an explanation for the Secretary of State of how the Secretary of State reached its assessment in the claimant's case, this is it. And the policy that's being referred to is at tab 42 of Authorities 2. And I'll take you straight to the serious offences policy. It's at page 67.
So page
67 of the printout.
Yes.
Bottom right corner. So the title of this annex to the policy is crimes where release from immigration detention or at the end of custody would be unlikely. So this is a presumption in favour of detention. And then you can see in the sideline passage further down other firearm offences. So in answer to the question posed by my Lord Justice Hickinbottom, it's not that the defendant says, oh, well, we look specifically at the intent that might underpin the title of the offence. It's, well, it was on this list.
We call this an annex.
I'm sorry, it doesn't quite follow on from the rest of the policy. So it's at the very back, and it's, if you look at the page numbers, they appear in the bottom right corner. If you go to 67, so we're in tab 42, which is the published detention policy applicable to everyone, the general detention policy.
Well, I see at page 65 there's Annex A, called a Bournemouth commitment. Is this part of Annex A?
That's specifically about drugs offences. So no, we're now moving. I'm sorry, I think I've caused confusion by saying annex. This is a separate document that's also appended to the policy, and it's at 67. So it's entitled Crimes Where Release from Immigration Detention or at the End of Custody Would Be Unlikely.
So it's just a separate freestanding document,
Yes.
is it?
Yes. So we'll see that
I don't
firearms...
really quite understand how it fits in the sense that we're not talking about release from immigration detention, we're talking about the beginning of immigration detention.
Or at the end of custody. What's meant there is at the end of the custodial part of the criminal sentence. So,
yes.
so if the defendant is right, then you look at somebody would have looked at the offence the claimant was convicted of. It's on this list. What do we do with it? And if you look, please, at page, if you now turn back to page 15, so this is now the general text of the policy, and it tells caseworkers what to do with this list of serious offences. And could you look at the second paragraph on page 15? In cases involving these serious offences, a decision to release is likely to be the proper conclusion only where the factors in favour of release are particularly compelling.
Now, where are you reading?
I'm sorry, second paragraph down. In cases involving these serious offences, therefore.
Yes.
And
these serious offences being?
the list we just looked at. So
How do you know that?
if you I'm just just going to try and find you the reference. It's not always My learned junior helpfully points out that if you look at the paragraph above and you see that the words "this list" are underlined, that's a hyperlink. So if we were looking at this online, we'd click on it and we would get this offence, this list of offences at the back. So
I see, so this list is
is-
67, is that
yes,
right? Yes.
precisely. And I would draw your attention in particular to the second sentence of the second paragraph. It says, in practice, release is likely to be appropriate only in exceptional cases.
You say that's a generic approach, which is impermissible.
Yes, this is quite, my lord, we say this is orphanopolis style presumption.
The first sentence as well indicates that.
Yes.
Because of the significant risk of harm to the public posed by those convicted of these offences.
Yes, but that is exactly, effectively, what the Germans were saying in Orphanopolis. Well, look, drugs offences, look what they do to society. And the Court of Justice in Orphanopolis says not good enough. You have to look at the individual facts of this case. Is it necessary on the facts of this case? Is there a genuine, present and sufficiently serious threat on the facts of this case?
And what did the judge say about all this?
So the judge is unimpressed, and I can take you to it. I wonder though if I should come back to that when I'm looking at his reasoning on period one. On this particular list of offences, he said this essentially could not obviate the need for individualised consideration. So
You won on this point.
well, we say that Mr. Anderson's only explanation for what happened in period one on the facts of this case is this policy. And
Well, I see that, but according to you, the judge rejected it.
the judge said that's not good enough. But
Yes.
we do say that he actually comes up with no alternative permissible explanation for what happened in this case in period one.
So why did the judge not say that you won on stage one?
And here is where we say, perhaps I should take you, I was going to take you to the facts, but what I'll do is circumvent the facts. I'll come back to those later and take you straight to a deputy judge's conclusions. I think that's a better way. So if you could turn up now the judgment. And this is certainly not an attempt to get around facts, but I think that this is where the question is leading. If we look at the judgment, turning first to the principles, if you could look at page 177 of the bundle. And this is where the deputy judge sets out his conclusions of principle. So in paragraph 25, he accepts the submission that the Article 27.2 standards must be met by each decision to detain. That's what the Secretary of State now accepts to be correct. Paragraph 34, he observes that it's not necessary for him to determine whether the Article 27.2 standards of proportionality and necessity are more protective in this context than Article 5.1F or the Harjour-Singh principles. At paragraph 35, the deputy judge gives this analysis of the previous criminal conviction safeguard. And we respectfully agree, but we say that this is actually not the test that was then applied. So, and I shall take you to the reasoning then. And this is, we say...
Referring us continually to points you won on, which of course is very impressive, but why did you actually lose?
And I shall show you that now at 56, but I think it's important for us to show what was accepted
Yeah.
in order to then understand where the reasoning goes at paragraph 56, and this is where we do lose. Paragraph 56. So, this is just a prelude to say, this, of course, the position to period 1 is that it's accepted that this period is unlawful.
Yes.
But there's no acceptance by the Secretary of State that substantial damages arise. And we accept, if the only error was the failure to give reasons, we accept that. So the question was then, is there something over and above? And and at paragraph 57, I should also say that the Deputy Judge rejected our challenge that there'd been no decision to detain at all. And
You don't appeal that?
no, we haven't.
What I'm eager to discover is why you decided this point against you.
So, could I show you also paragraph 59? This is the essential factual matrix, and this is coming up to where we do lose. So, all the Secretary of State knew at stage 1 on 27th of January, and again at stage 2 on 28th of January, was the claimant's name, date of birth, Lithuanian nationality, the fact that he'd been convicted and sentenced to 14 months in custody for a first offence of possession of an imitation firearm, and that the custodial term had immediately expired. Nothing was known about key topics, materials such as the judicial sentencing remarks and the pre-sentence report were requested, but that information gathering was only started on the 29th of January. So no information gathering. This is the factual matrix. There is no information, but nor are there attempts to get information in period 1. So there is...
Yes, well, these are all comments about the facts,
Yes.
Which no doubt are helpful, but really we need to find why the judge decided stage 1 against you.
Could I show you... I do want
Well, shall I tell you where he does it then? It's paragraph 61, isn't it?
Quite so, my lord, but we do say it's... Well, I won't try and...
Why is he wrong in paragraph 61
So-
to say in the 6th line, 5th line, the requirement of individualised proportionality and necessity can, in my judgment, cater for situations where very little is known about the individual, but there are real grounds for concern, provided always that the recognition of that situation is accompanied by a recognition of the need to obtain such full information and imperative urgency. That's where he comes to his conclusion. And then lower down, he says, the protective approach is perhaps encapsulated in Immigration Officer Zabardaz's phrase in the form ICD 3079 that in the known circumstances it was not considered reasonable to leave the public vulnerable to the potential for him to re-offend. Executive detention is serious and further information is done and so on. Now those two sentences are the judge's conclusion. Now why are those sentences wrong?
First, our maximalist submission. So you will have seen in our speaking note we've got 2 submissions on period 1. The maximalist submission is that you can never, even in urgent circumstances, detain purely on the basis of knowledge about the class of offence and the length of sentence. So there was no information about the behaviour, as Lord Justice Morgan put it in nicely.
And so the judge is right to say that the requirement of individualised proportionality and necessity can, in my judgment, cater for situations very little is known. You say that's wrong, I'm sorry, and there can never happen in that situation that when little is known about the individual, then you can never have an individualised proportionate assessment.
Our maximalist submission is yes, there is no authority in EU law that says you can depart from that particular Article 27.2 safeguard. And we don't seek a reference, we don't urge upon you a reference, because we say there's that clear in our
Well, the judge does give particulars, because Mr. Zabardast, says it was not considered reasonable to leave the public vulnerable to the potential for him to re-offend. So the immigration officer looks at what has happened. He says, well, this is likely to be an offence which is going to be repeated, and on that basis I have to protect the public and will detain him. Meanwhile, no doubt he had in mind all the things about imperative urgency that was necessary for him to get the information. So, but you say that is an impossible situation to have.
Yes, and we would also say, the caveat that actually what the immigration officer Zabadas is saying is, as in the case of X, where the Secretary of State's letter essentially says you've committed murder, if you do it again that would be very serious, but there's no assessment of whether he will do it again. Here there is no possibility of any assessment of whether the claimant will in fact re-offend. All that's said is we know the class of his offence, it's serious, we don't want it to happen again, and we want to protect the public from the potential of it happening again, but that's not enough. There has to be an assessment of the behaviour.
So however much the immigration officer might think from the fact of conviction that there is a likelihood that the public will be harmed, he has to release him.
And we say, of course, that the way one deals with that is by setting up a system that avoids this situation arises.
Yeah.
But so that's our maximalist submission, is that as a matter of principle of EU law, that's not right. And just to complete what I was saying about a reference, we say if you're minded to reject that submission of principle, we would respectively say that a reference would be necessary, because the step that Mr. Anderson is urging upon you, and of which he convinced the deputy judge below, is actually a radical step. It's very easy for us to say, well, it's a one-day detention now, we are really having this argument about this, but what the argument is really about in period 1 on the maximalist submission is, can member states ever depart from or dilute the Article 27.2 safeguards in the absence of any principle or any authority that says so?
I'm going to say I don't see this as a matter of law. The judge accepts, everybody accepts, that there has to be an individualised approach.
Yes.
Everybody accepts, or the thought, that you can't simply drive a coach and horses through the Article 27 safeguards. In paragraph 61, which, as my lord says, this is why the deputy judge rejected your submissions in relation to stage 1. He refers to the requirement of individualised proportionality and assessment. What you say, though, is, it's not, I don't think, a matter of law. You say that on the facts of this case, where Mr. Zabardast, who seems to have made the decision, had no more than the fact of the conviction and the sentence, he could not make an individualised assessment. He simply did not have anything upon which he could properly find that there was a threat to public policy.
My lord, one thing I'm concerned about confusing is that the decision of Immigration Officer Zabadas that's been referred to isn't in period 1, it's in period 2. It's on the 28th of January. So we don't have that. All that explanation is entirely missing from period 1. We simply have...
I'm sorry,
yes.
That's my fault. Just leave
yes.
Mr. Zabadas out of it.
Yes.
But in period 1, you say there simply wasn't sufficient information for whoever made the decision or failed to make the decision, because there are no reasons, you won on that, could make the necessary individualised assessment of threat. You say that stage 1 is, in principle, exactly the same as stage 2.
Well, my lord, we'd even say for sure, right? Because there is simply nothing. There is no reasoned decision, there's no justification, there's nothing going on in period 1. There's no information gathering, there's no reasons, we simply don't know what the justification is. But could I come back to this question about whether there is an issue of principle? We do say, paragraph 61, there clearly is, because what the deputy judge says is the requirement of individualised proportionality and necessity can, in my judgment, require for situations where very little is known about the individual, but there are real grounds for concerns, provided always that the recognition of that situation is accompanied by a recognition of a need to obtain such full information as available about the individual's conduct, circumstances and risk profile with imperative urgency. So he's effectively saying you can, on a precautionary basis, detain without knowing more than the title of the conviction and the length of sentence. And we say on our maximum submission, that's simply not right. But can I turn now to our fallback submission?
Well, no, I'd like to just
Yes.
follow this through
Yes.
a bit, because I'm afraid I haven't appreciated that, and I'm sorry to go back to Mr. Zabadast, that it wasn't him who made the initial order. I read this as applying to stage one because the judge keeps on talking about stage one. Maybe the judge was under a misapprehension, I don't know. But I think, could we be shown, please, A, the authority for detention by whoever it was, and B, the document the judge is referring to as ICD 3079.
Certainly, my lord. If you could turn to the core bundle, could you start, please, at what are the GCID records? So those are computerised printouts.
These are in the core bundle, are they?
I'm so sorry, supplementary bundle. I'm so sorry. So these start at page 249 of the supplementary bundle.
Yes. Remind me, GCID stands for?
And I think I may have to ask Mr. Anderson for his help there.
My lord, we will see if we can clarify that, but effectively it's a central record on which their entries are made by the Secretary
Someone
of
tell
State.
us in due course what GCID is, please. Now, 249, this is the continuous record, so this is the actual record of detention,
Yes.
not by Mr. Zabadast, but by somebody called...
Orla Fleming. So, and so one always has to look at the bottom for the signature of the person who is making the entry, or the name of the person who's making the entry, and the date. So,
Well, I see Miss Zabadast, as it turns out, at the top of page 250.
yes.
Is this her document or not?
So different names appear throughout this. So I'm showing you now the computerized printout, and we will see a series of immigration officers coming up, and I'm showing you now the
Now,
first...
I've asked you two questions.
Okay, yes.
One is the initial detention, and the second is whatever ICD 3079 is. Those are the two documents that I, at any rate, would like to see.
I'm sorry, I was going to... yes. So, that's the IS91. Yeah. Yes. So,
This looks like to me
Yes,
a
yes.
request for information.
so can I just show you first, because because actually it's very hard to read the documents without looking first at this computerized records, which does illuminate what's going on. So if you look at the GCID records, if you start at 249, please, and then look to the individual documents. So
There must somewhere be a signed document authorising the detention of your client.
it's so the
I would have thought that's
initial
the most important document in the case.
so the initial authorization is called an IS91 form. I can take you to that now. I was going to show you first the circumstances in which it's produced. It's 47 to 48.
47.
Yes. I beg your pardon. It is pages 47 to 48 of the core bundle.
Of the core bundle.
I'm so sorry, supplementary bundle. Supplementary bundle. So it's a checklist form that is given to the detainer to say you're authorised to hold on to this person. And there's no photo on it that we've assumed for these. You've been prepared to assume that there was a photo on the original. So this is the initial authority to detain. This is all there is on the 27th in terms of an authority to detain.
I'm sorry, which page are we on?
47 of the supplementary bundle.
47.
Yes,
Yes. Right, so this is the authority to detain.
yes.
Yes.
And this is as far as it goes. And this is signed, you'll see, by Paul Benson.
And so this is a gentleman called Paul Benson.
Yes.
Yes.
And
Now, let's just have a quick look at it then. There is a section 2 is detainee information to be completed by the immigration officer. So this looks as if it might be individualised. The box crossed is what?
is the standard.
person who the Secretary of State is considering whether there are reasonable grounds for suspecting that they may be removed.
So what these boxes do is ask the detaining officer to identify the statutory basis for detention.
Yes. And then we have box 3, or section 3, and section 4, risk factors.
Yes.
So again, that might be a matter of individualised detention. Is any box ticked here?
Yes, my lord. Violence toward or assaults on others. So that is all, of course, purely on the basis of a title of conviction.
Yes. So I thought the judge was referring to some document like that in paragraph 61, but he's obviously not referring to that. Which document is he referring to?
So when he refers to Immigration Officer Zabadast and ICD 3079, that is the start of period 2. So this is the first time we get a reasoned decision to detain, and that is at page 52 of
And the date of 47 is presumably the 29th of January, is it? 27th of January.
27th
Yes.
of January. So that's all there is for the initial detention, 27th of January.
Yes.
Then on 28th of January we have the first reasoned decision.
And that's 247, is it?
That's at page 52.
52.
Page 52 of the supplementary bundle, and this is Immigration Officer Zabadast's decision.
And what's the date of this?
So this is the 28th of January.
So this is the following day.
Yes.
And so this is actually stage 2 then, isn't it?
Yes, so that was my point earlier, that
Yes.
I wanted to make sure we weren't getting confused.
Yes. So this is document ICD 3079, is it?
Yes. And could I just, while we're in this, just to avoid having to come back to it in period 2, show you underneath the consideration heading, evidence of compliance with immigration control, we know he has freedom of movement, details of claim ties, none known. And then I was asked earlier about whether there was any assessment of absconding risk. This is as far as it goes. He's been serviced with an intent, notice of intention to deport, compassionate factors, none known. Evidence of previous absconding, none known. Evidence of other previous disregard to immigration laws, none known. Other relevant factors, none known. And then under proposal, and I say all this with the caveat this is all about period 2, but we do say this is precisely the sort of reasoning that is unlawful because there is no assessment of propensity to reoffend. It's only about what will happen if he does reoffend. We have, whilst he does not have an extensive criminal record, this was his sole offence, the Home Office takes the view that the serious harm which would be caused as a result of any similar instances of offending is such that it's not considered reasonable to leave the public vulnerable to potential for him to reoffend. And then afterwards we have a rather troubling paragraph about no evidence of offending behaviour courses, and of course offending behaviour courses aren't available to remand prisoners, so he couldn't have satisfied that criterion. And then could I turn you to the authorising officer, which is Sue Yildiz at page 54. Based on the information contained in the above proposal, and this is very important, given that Mr. Lauzikas has been convicted of possession of an imitation firearm, and parenthetically I point out there's no reference here to intent, but he's been convicted of this offence, resulting in a sentence of 1 year, 2 months, I've assessed the legality of his detention. And at the bottom, I consider the facts and satisfied detention is both reasonable and proportionate. So this is the basis of the detention on the 28th of January. So the information contained in the above proposal, there is almost none, and given that he has been convicted of possession of an imitation firearm resulting in this sentence.
Yes, right, I think we've got that. Thank you very much. And I think we have your submissions, therefore, that whether we haven't looked at the first document or the second document, that is not an individualised approach and it doesn't comply with Article 27.
That's our maximum submission. Can I turn now to the minimum submission?
Yes.
Just before we leave stage 1, because this is your appeal. Page 249 suggests that the relevant casework that we've ever done, perhaps Fleming, was notified that this individual was due for release that day, was told that he'd had a sentence of 14 months running in one span, and then requested a stage 1 letter will be completed, and then the IS 91 was faxed to the prison for service. So that's it. That's all that happened.
And can I also, yes, my lord, and actually the other point I wanted to make here is that the deputy judge was rather sceptical about the lack of proactive liaison arrangements between the criminal justice authorities and the Home Office, but taking it the other way, there is some liaison. So they are in communication with each other, because obviously the criminal justice authorities get in touch with the Home Office and say, it's about to be released, and presumably that's where the PNC, the Police National Computer Printout, comes from. And Form CCD2, our understanding is that's a referral form. We don't have a copy. But our understanding is, having looked this up, that Form CCD2 is a form on which criminal justice authorities refer a person to the Home Office for deportation consideration. So there is actually immediate contact between the Home Office and the criminal justice authorities, but it's inadequate because there's information already in existence, such as a pre-sentence report that had in fact been created on the 31st of December 2014, an OASIS report created on the same date, that are not sent over. So turning to our minimalist submission, we say for a deprivation of liberty to comply with Article 6 of the Charter and with Article 27.2, it must be strictly necessary to detain this individual in these circumstances. And we say that's clear from the case, for example, of Kay, which I showed you earlier. So given that, the test of necessity that the deputy judge should, we respectfully say, have been applying to period 1, he should have been asking himself, first of all, is it necessary to detain this person now for information gathering because the process could not have begun earlier? Secondly, is this time actually being used for information gathering? So one, in other words,
remind me of what your minimalist submission is, to understand this.
and my lord, if I could ask you to turn back to the note that I handed up to you at the start of the hearing. It's at page 3.
Your speaking note?
Yes, the speaking note, I beg your pardon. Page 3, paragraph 3. And so this is the minimalist submission, period 1.
Yes.
So in any event, must be strictly necessary. So even if we're wrong that there's no discretion under Article 27.2, even if you can have this short grace period in which to conduct a fuller inquiry, it still has to be strictly necessary. And we say, just going from this note, standard can't have been met because, as he observed, as the deputy judge himself observed, the pre-sentence report was available 3 weeks before detention began. And parenthetically there, we'd say, look, when they were liaising on the 27th of January, it was of course perfectly possible to send that information over along with this CCD2 form and the PNC, the Police National Computer Printout. And the other point we make is the period does actually have to be used for urgent information gathering. So what the deputy judge does, coming back to my Lord Justice Longmore's question about what is his reasoning at paragraph 61, he essentially is saying, persuaded by Mr. Anderson, I accept that EU law can accommodate this sort of precautionary detention in urgent circumstances. But he doesn't then go on and ask whether on his own factual findings those were made out. And the only conclusion he could have reached was that nothing seems to have been going on in this period. Certainly not in terms of information gathering, because if we look, if you still have it open at page 249 still, so we're still in this GCID record, and hope we'll find the acronym shortly. I'm told it may be General Case Information Database. So in this computerized printout, at the bottom, you'll see when information gathering starts.
Yeah.
And the date is actually over the page, but it's still the 29th of January. But you'll see information gathering, following documents requested, trial record, we think, judicial sentencing remark, and then presumably national insurance contributions, and then a check on any appeal. So that happens on the 29th of January. It's not in period 1 at all. So
Why would his national insurance contribution have any relevance?
my lord, it would to the question potentially of whether he was, whether he enjoyed some enhanced protection from expulsion. For example, was he legally resident? Was he exercising rights more than 5 years? So somebody who has been in the UK for a long time, it's not the case for the claimant, might need to, too much gesticulating. Somebody might need to be able to point to their national
You
insurance.
don't have to make your solutions while you're running around the court.
Yes, thank you. Yes, so in those circumstances, somebody might want to prove how long they had been working. Yes.
But there doesn't seem to be any reference to the pre-sentencing report then. No, OASIS report at the bottom, yes.
Sorry, they're having
PNC?
now. At the bottom, we have OASIS report. Yes, that's quite right, my lord. Yes. Yes.
So here we are on the 29th of January, and somebody, Mr. Zabardast or Miss Zabardast or someone else, is asking for this information.
Yes.
Yes.
And the unexplained lacuna is what was going on before the 29th of January. And I think it's right to say that the 27th of January was a Tuesday. We did check whether this gap could be explicable by weekend. It's not. It's all weekdays. So the other point that we make here to wrap up our submissions on period 1 is that the other error is to take the system as you find it, as a judge applying EU law principles, rather than to ask whether the system sufficed to...
Well, it's a little unfair to the judge, because he does say, doesn't he, about line 10 of 61, that it would on the face of it be best if proactive liaison arrangements between the Home Office and criminal justice authorities made in a more informed position from the outset and so on, doesn't he? He says that would be good practice, effectively, but he's saying it's not an actual requirement.
And what we say he's not examining there is, could you have had active liaison arrangements reasonably? Could those reasonably be expected in this scenario? Or was it really something that was effectively impossible or unreasonable to expect of the Secretary of State to have such a system?
The Secretary of State can't predict what sentence somebody's going to be given, can he?
No, my lord, but you could easily imagine a system where, given you do have some immediate transmission of information happening here on the 27th of January, but you actually transmit all the information that's in existence rather than have a sort of dance of the seven veils and this drip of information that comes in, and as my lord points out, not even asking for the pre-sentence report that, as it happened, had been in existence for over 3 weeks previously. And I shall just very quickly point, mindful of time, to the fact that there are authorities, both in EU law and actually in Article 5.1f, and we say the position in EU law must be a fortiori for the reasons already given, that say you've got to have a system that keeps to a minimum an unjustified restriction. The EU law case is called PEHPA, I hope I'm saying that correctly, and it's Authorities Volume 1, tab 9. And this was a case about pharmaceutical importation. So it doesn't, of course, attract the particular Article 27.2 standards applicable to free movement of people. It doesn't attract the stringent Article 6 of the Charter strict necessity test. But nonetheless, in this context about restrictions upon free movement of goods, the court is saying you need to look at whether the system is adequate. And at paragraph 239, I'm so sorry, no, it's, beg your pardon, it's page 304 of the report. So first of all, it's paragraph 17, page 304. So the question was whether the restrictions that were being imposed by the Netherlands authorities were upon importation of pharmaceutical products fell foul of the right to free movement of goods protected by Article 36 of the EC Treaty. And 17, it's that the necessity test is being applied. So they don't fall within the exception if the health and life of humans could be as effectively protected by measures which do not restrict inter-community trade so much. And then paragraph 18, importantly, in particular, Article 36 cannot be relied upon to justify rules or practices which, even though they are beneficial, contain restrictions which are explained primarily by a concern to lighten the administration's burden or reduce public expenditure, unless in the absence of a said rules or practice, this burden of expenditure clearly would exceed the limits of what can reasonably be required. So not enough that the alternative system would be more expensive or more burdensome. You have to ask, is it unreasonable
Seems
to
an awful
apply
long
this?
way away from this case. I thought you were going to James' authority, which said you must, the authorities must take a proactive line in order to forestall any problems about unauthorised detention. To have a case about import of chemical goods seems a very long way away. Is that really the best you can do?
Well, my lord, I actually am going to take in a moment some Strasbourg jurisprudence. It is about deportation and detention, but why this is helpful to us is precisely because our case is a fortiori. So if these sorts of standards are being applied to restrictions on the free movement of goods,
Really, it's the best case you have, is it?
It's the most on point case we have, my lord, and I wish we could find something directly on point, but we think that this does establish clearly the principle. So if you look again at paragraph 32, the court went behind the entire system of documentation that was being required of importers by the Netherlands authorities and carefully considered whether those, even though they might be easing the administrative burden of the Netherlands authorities, were in fact necessary, and then goes on to say, must be regarded as unnecessarily restricted, cannot come within the exceptions unless it's clearly proved. So of course the state imposing the restriction must prove the necessity. Unless it's clearly proved that any other rules or practice would obviously be beyond the means which can reasonably be expected of an administration operating in a normal manner. And
so,
of course,
so where is that?
I'm so sorry, paragraph 32.
Okay.
And here again, it is critical that, to use the Deputy Judge's words, importantly, the Secretary of State has not filed witness evidence. We just have no witness evidence as to why a better system of liaison could not have
Yes,
been.
well, I think we've had enough on stage one, Mr. Dubinsky. We understand what your position is. I think that after 2 o'clock you should move on to stage 4.
Certainly.